I'm waiting for my, okay, I got my thumbs up. I can keep going. So good morning, everybody. I am the only thing standing between you guys and lunch, and I need to get my timer going because I would hate for you to miss lunch. That would probably make all of you mad at me, and I don't want that today. And I need to move closer to the mic probably for the people online and need to keep that in mind as I do this. So yeah, we're going to do the 2022 legal review, and then we'll talk about what to look out for in 2023, where I work through some personal problems on some court decisions. Uh-oh. Oh, I screwed up. Okay. So with this, when I was putting this together a few months ago for another group and then kind of updated it for this group, I thought about how's the theme for 2022 and 2023? How many people watch Parks and Recreations? We're going to talk a lot about Ron Swanson's favorite foods in this, those being eggs and bacon, but we're also just going to start off with broilers and chicken because there was really no other way I could fit this in this theme, so it really doesn't fit at all times. So we are going to spend a lot of time on pork and eggs and chickens. So how many people know about the poultry class litigation that is ongoing with settlements? I see one person who has, Holly knows a little bit about this. Growers are getting these letters in the mail. Uh-oh. Yeah. So I forgot my slide there. Yeah, so these have taken two forms in 2022. First, we have these settlements involving Packers and Stockyards Act violations that I'll talk about first. And then we have claims by former growers that they are not actually independent contractors. They are actually employees of these companies. We'll start with the broiler settlement, which is also known as Coke. So this was filed originally in 2017 with claims that basically these integrators colluded on the broiler market, violating the Packers and Stockyards Act. For those that don't know, the Packers and Stockyards Act is this antitrust law that has been around for over 100 years that lays out how Packers can work within the industry, and poultry has been added in more recently. By recently, I mean about the 1960s. So they have been added in. This is a way to prevent collusion within the market and create some stability within it for growers. So the claims are basically that the integrators agreed to basically not poach growers. So if you were growing for one company, they weren't going to come over and poach you to another company. That was agreed upon. Then basically the argument is, how many people know what AgriStats is? Okay, the few people in the room. This is a company that pulls together the grower data, company data, and puts it out there. This data is supposed to be anonymized, where they cannot tell who the people are within this system. The argument is that has been made within this litigation that this data is so centralized and you can get it down to an exact farm to tell who it is. Even though it's anonymized, you are able to tell if you're the company who the exact grower is through that. And they use this data to lower grower compensations. Move on. So basically this lawsuit was brought against Coke Poultry, Pilgrim's Pride, Sanderson's Farms, Tyson, and Purdue. Currently, only Coke has settled. And by currently, I mean, this was like 2 weeks ago when I put this together. I didn't look before I came here. I forgot to look at that. So that's, the other companies may have settled, but at this point, they have not settled yet. And my guess is they have not settled. I'm not going to read that list of co-conspirators off. That is the full list of co-conspirators that comes directly from the pleadings. This is almost every poultry company in the US is listed there, plus AgriStats. AgriStats, I believe, has since changed its name to something else. What are we doing with this settlement? Well, for the most part, one date has already passed. September 23rd has passed. If you wanted to be excluded from the settlement, you had until September 23rd to file a form and be excluded from the settlement. Fairness hearing is today. The court will go in and look to determine if this settlement is actually fair to all the parties involved in the settlement, and then it may move forward, it may not move forward, depending on what it is. If it does move forward, Claim forms will be submitted out to growers. Some of them have already started getting these forms. If their data is correct in the form, that attorneys that are involved in this litigation is getting information from the companies as a part of this settlement process. They may not have complete information. So if you're getting these settlement forms, you need to go in and correct that data so folks know what is going on and what the right numbers are that need to be in this. There will probably be a website set up where all this can be done. Technically there is one, I believe it's broilersettlement.com, but you have to make sure you go to the right broiler settlement in it. There are 2 ongoing broiler settlements right now. One is already passed. This is the most recent one. That's just our first poultry class action lawsuit. Let's move on to the second class action lawsuit, one that is much more interesting and fascinating than the actual broiler settlement. So this one is the Fair Labor Standards Act litigation. These growers are suing under the Fair Labor Standards Act. How many people in the room know what the Fair Labor Standards Act is? Basically lays out more or less how employers should treat employees, what we expect out of employees. There are ag exceptions in it. We'll talk slightly about that in this, but that's kind of what this litigation does, or this law does. So with this, we've seen 2 of these this year, one in Georgia and one in South Carolina. Both involve South Carolina growers. Both are bringing claims that the integrators violated the Fair Labor Standards Act. So move on. Basically, if you look at any poultry contract for any grower, it lays out they are independent contractors. These former growers are arguing they are not actually independent contractors. They are employees. If they are an independent contractor, they are exempt under the Fair Labor Standards Act. Companies can provide them with whatever compensation they want to. Minimum wage laws do not apply at that point. They are an independent contractor. Before I go on, should I explain what an independent contractor is for everybody in the room? Basically, you do your work. When you decide to do it, you're hired to do it. You're making your own decisions in the job. You get paid based off what you agree with the person. If you're employee, the company is much more telling you what to do in that situation. So if they're employees, they have to be paid a minimum wage. And the argument is they're working over 40 hours a week or whatever in the various states the ag rules are for overtime for ag workers. They are owed time and a half for overtime at that case. They are claiming that the tournament system does not pay them adequately to meet that compensation goal. And they are not being paid at least a minimum wage under the state law. One of these lawsuits, the South Carolina lawsuit, is claiming that they have violated the Employee Retirement Income Security Act. Who in this room knows what the Employee Retirement Security Act does? Brooke does, but Brooke has also been looking at this litigation too. So Brooke is in a different situation. I didn't know what this law was. This is a federal law. It lays out that if you offer benefits to one class of employee, you have to offer it to all employees in that class. So if you think about it, the way companies are structured, we have differences in how employees are handled. Some are given certain benefits, others are not. This is all to stay in compliance with this federal law. Their claim is within this litigation is you are offering these benefits, retirement, health insurance, other perks, we're not getting as employees. You've violated this law and there are penalties associated with this that they are claiming the companies owe them in that case. That is only in the South Carolina case. Oh, I went too fast. It'll go back. So where are we at in this? There's only been 2 filed. We still got to wait to see if this is even going to be certified as a class action. I have learned way too much over class actions over the past 4 years, it feels like. So we will have to figure out if there are actually commonality in all these claims between the 2 cases. figure out if we can actually settle this through a class action process. If that is, it will potentially be consolidated and a federal district court will be decided on where this will be held. It will either be currently in South Carolina or Georgia. We don't know where, we don't even know if it will be settled by this. I say there is some case law to back up growers' allegations. We have never actually had an employee-employer litigation. Much more of the independent contractor stuff has been litigated on the environmental end and not so much on the employee end. So this is going to be an interesting case to follow over the next couple of years as it plays out. For those that don't know how class actions will play out, if this actually is certified and we get to trials, we will have bellwether trials. We will have one set of bellwether trials that is best for the plaintiffs and one that is best for the defendants. And depending on how those turn out, that will help us determine what the settlement will be in all of this. Or it may not actually go to trial. We don't know yet. We are just at the pleading stages. And in most of these, there were some delays in getting answers filed. So I believe in one, there's actually been an answer filed actually. The Georgia one, I don't think there's been an answer filed in yet. Are y'all tired of chickens yet? We're still not done. We still got a few more things to talk about. This one's just really quick. Over the summer, USDA announced proposed changes they would like to make to how the tournament system would play out. I say comment closed earlier this month. That was actually back in September. I forgot to update this slide from the last time I gave this presentation, but those comments have been changed or closed. There will probably be a proposed rule coming out laying out what this would be. For those that don't know, it would potentially just provide growers with more information that they may or may not actually need. And if USDA moves forward with this, does anybody know what we can expect? It's what we've expected every time on this rule. Every time it happens, we will have lots and lots of litigation on this rule, and we will be making attorneys richer and richer. And that never makes anybody upset, right? Nobody gets upset when attorneys make money. So yeah, that's where we're at. We expect that if this goes forward, there will be lots of litigation potentially on this, or Congress will move to basically not allow the administration to move forward depending on how the election turns out. And now we're done with chickens partially, and we're going to move on to pork. And this is where we're going to spend the bulk of our time. How many people know what Prop 12 is? How many people have heard of Prop 12? No one's heard of Prop 12. Okay, so let's lay out what Prop 12 is first. So basically, this is a law passed by California voters in 2018, and it basically covers how pork and eggs should be produced, lays out minimum standards for animal welfare as to how those should be done to be brought into the state of California. Basically, Prop 12 limits the use of gestation crates within the pork industry, which are used with breeding sows, and then battery cages with poultry growers who are doing eggs. Forget what my next question was, but we'll move on from that. So the majority of eggs and poultry, or pork and eggs sold in California do not actually come from California. They come from other states. They come from Iowa, particularly, and other Midwest states that do not have limitations and do not have animal welfare restrictions on how these products are raised. So there are claims. Who are all the law students in the room? Not to single you out. How many of you have loved talking about the Dormant Commerce Clause in law school? How many of you think about the Dormant Commerce Clause when you want to have a nightmare at night? It's better than the rule against perpetuities, but we will not go down that road today. So there are basically the pork industry and several ag groups are working and have been making arguments since 2018 that Prop 12 violates the Dormant Commerce Clause. For those that don't know what the Dormant Commerce Clause is, basically the US Constitution lays out that Congress shall have all authority to regulate trade amongst the states, the nations, and the several Indian tribes. Is California laying out regulations with this on how products should be produced? Potentially. We'll talk about where that's at here in a second. Okay. Yeah, so that's what the Commerce Clause does. The Dormant Commerce Clause basically lays out, this is not actually written into the Constitution. This is a development that came about in the 1800s, that if we gave Congress this power to regulate commerce, we can't just let the states go around and do things that could discriminate against each other. So Maryland could set out a rule that, you know, certain products coming into the state can't come from Delaware. We don't want anything from Delaware coming into the state. We'll use that as our basic example. That violates the Dormant Commerce Clause because only Congress can really regulate trade amongst the states. The states have some ability if there's, you know, a general policing power involved for the health, safety, and welfare of citizens. Like for instance, if we know bringing lumber into the state produced in from certain states could bring diseases into our forest industry, that would be a reason we could keep that product out. We're not discriminating. We actually have a reason we want to do that. We want to keep a pathogen out of the state. That is where we're at with this. We're going to get to the fun part so far. Initially, none of the federal courts agreed with these claims that this violated the Dormant Commerce Clause. The first part was states' attorney generals in these ag states brought claims claiming this violated the Dormant Commerce Clause. The issue with that was these attorney generals have no standing to bring this case. They needed an actual person who was going to be impacted by it. So then the trade groups got involved and restarted bringing the same comments or the same claims basically. Throughout most of the federal district court proceedings, Court of Appeals, they have not agreed with this so far. They have not found the Dormant Commerce Clause violation in any of this. This was heard last week, or not last week, about 3 weeks ago by the US Supreme Court. So we can have a little bit more to talk about than the last time I talked about this. At the same time, Justice Department came out and actually filed briefs to support the ag industry in this. They view this as a huge problem if this passes. We'll talk about why here in a second. Those oral arguments were heard last month by SCOTUS. Anybody follow the oral arguments on any of this? Who is the one Supreme Court justice that never talks in any of the oral arguments? Thomas. Guess who the first person who talked during this was? Thomas. You know what got Thomas to talk? Bacon and eggs. Bacon and eggs got Thomas to talk. He asked a lot of questions. All of them had questions. If we go to my next slide talks about. From the transcript, it's a fascinating transcript read. I rarely read Supreme Court oral argument transcripts because they're usually boring. This one was kind of fascinating. And based on reading them and some of what I've seen in the media, it looks like Thomas and Gorsuch would vote to uphold the law. Why? They're libertarians at heart and they believe, you know, state legislatures should have some ability to regulate things. So they view this as not a problem. Alito and Kavanaugh, they don't seem to be willing to uphold this law. They seem to be two people voting against it. Sotomayor, Kagan, and Jackson all appear to be siding also with California. That's at least where it comes out. We don't know. Are we ever right when we guess based on how justices ask questions during oral arguments for the attorneys in the room? We're rarely right. We might have a general sense of where we're going to be, but we're never right. So it appears right now that we have a 5-2, maybe 6. No, I'm skipping. I forgot somebody in all of this. I forgot at least 2 justices. Oh, I forgot Brown and Barrett and yeah, those were the 2 I could never quite figure out where they were going to turn out. So we don't know exactly where, but it looks like we have 5 votes to uphold right now. And we don't know where the others are going to turn out. What happens if we uphold this? In law school, you're taught the parade of horribles, right? What are some horrible things we could add into this? Y'all didn't know there was going to be audience participation while I presented, did you? It's much more fun than doing it on Zoom. None of you could actually participate. What other crazy things could we put in place? One example. Could we set other standards in place beyond ag? Could you produce, everything has to be produced to a certain minimum wage, to a living wage. Basic health care has to be provided to all your employees. What else do you want to throw in there? Electricity is generated. You could throw anything in this if this is upheld. At least that's what most of the arguments are. It's fun to go to SCOTUS blog and look about ag cases right now. This will. Now I go on to my fun part. What happened in US history in 1787? Just a few miles up the road. Then we produced the Constitution. Wasn't the idea to go away from state legislatures actually being able to do this and force their will upon other states? Didn't we want Congress to actually do this? If by upholding this, are we ceding power from Congress and the executive branch to state legislatures? I'm guesstimating it was a 3 to 4 day ride from here, and I could never find out how many days ride it was from Annapolis to Philly. That's one of the problems we're potentially running down with this law being upheld. For the law students in the room, what's the ag case you have to read in con law? You read Wickard versus Filburn. Most of our constitutional practices in Commerce Clause litigation was started because one farmer, I forget where he was located, wanted to keep wheat on his farm. And that set most of our constitutional practices with the Commerce Clause in effect. It could happen with another ag case too, which could create a lot of fun issues for attorneys to figure out and what the bright lines would be. I think my next slide is just my examples I've already walked through. Yeah. As I already kind of hinted at, there's a concern among many scholars and many commentators that if Prop 12 is upheld, it opens a Pandora's box beyond ag. It is every industry is looking at standards being placed on them by other states that now they have to meet. So I already used the one that you would have to pay a certain minimum wage to your employees to be able to do that. That is a huge problem, potentially. We expect a decision sometime in 2023. My guess is we'll get it in June. May or may not be one of the last ones issued. We may get it earlier, but typically this may be one that comes out late June, depending on what it is. This could create a lot of issues to where basically everything the law students have learned about the dormant Commerce Clause is thrown out the window and we have to look at a new case, depending on what the ruling is. I'm not all gloom and doom most days. And then I'll get to y'all's questions because we can play Stump the Chump for a while. My last things to talk about. Recently, the 8th Circuit vacated a $60 million punitive damage award awarded by a federal district jury in Missouri to a peach farmer who had drift damage from dicamba. The reason they vacated this decision is not that the damage award violated any of the state laws. It was actually reduced to the benefit of the state law. But when the judge gave the instruction to the jury on punitive damages, I believe in this case it was BASF, and I cannot remember the seed company that was involved in it off the top of my head. The judge did not actually give the proper instruction. It was only should have been given against one company and not both companies. There was not evidence towards the other company. So basically both companies were lumped in together. They have to go back and relook at this punitive damage issue and seat another jury and relook at this issue to determine what that proper amount should be and if the other company should be lumped in with a settlement. So that's something that will move forward probably next year. That's one of the first dicamba drift cases that went to court. Next month, the Maryland Court of Appeals will hear an appeal in the MDE versus Assateague Coastal Trust case. This is the decision basically appealing the lower court decision that found that MDA has to take air admissions into account through the CAFO permit. So we're using a water quality permit to take into account air quality issues. This is going to be interesting to see because most of the court decisions involving air quality, the federal district courts have ruled that that does not have to be taken into account during a water quality permit. We are the outlier on that so far. So it's going to be interesting to see how the Court of Appeals makes that decision and how some of these past decisions, at least within the federal system, play out in upholding or moving it in us in a different direction. Supreme Court will not hear, they decided not to hear the appeal in Bayer's litigation over the glyphosate cases. How many people still get the commercials about glyphosate? Or are we all on to the Camp Lejeune water issue now? Yeah, I'm getting more Camp Lejeune now than I am glyphosate on my TV at least. So these were cases, this involved a homeowner, if I remember correctly. And the decision there was, Bayer was arguing basically that because EPA has put a label out on this product that says it's safe, tells you how to use it, a court cannot come back in and then declare it unsafe and provide these damages that they've been providing. They've lost that pretty much the whole way through the state court system and through the Ninth Circuit. The Supreme Court will not hear that decision. On to my favorite topic, right to farm laws. For the longest time, Iowa was the only state in the union that found their right to farm law unconstitutional as applied to almost every case that came before it. What is Iowa becoming known for besides corn and soybeans? What animal do they raise a lot of? Pigs. In almost every case involving this, it involved a new hog farm going up. And in almost every case, there was a permitting process to go through to appeal. Most homeowners would wait until the farm was constructed and then sue under negligent or nuisance, and then the right to farm law wouldn't apply and they would effectively shut the farm down after it had been built, not in the permitting process. A number of courts had gone away from that and said, look, your process you want to do this at is at the regulatory side. We don't really want you doing it this way. Iowa came back and said the test that they had created is too hard to actually follow by most trial courts. It really was hard for most trial courts to follow based on some of the court rulings they had. They have now moved to where that previous set of line of cases no longer applies, and they will just look at it like most other states do. If you meet the qualifications, the law applies now. I do a blog at agrisk.umd.edu, and I time this perfectly to give me 15 minutes for questions. I believe next I read them to you. Oh no, I'm also a part of this. I'm working with the Southern Ag Extension economist at southernagtoday.org. They're doing a weekly or daily blog, similar to Farm Doc, but much shorter, covering everything from farm finance, trade, policy, farm management, and then ag law is on Friday. So I'm one of the topic area leaders for that and help review, post every now and again for that. So if you want that, you can sign up there. That QR code should work too. And I have cards if you'd like them. They sent me a whole box of them and I'd like to get rid of them. What questions do folks have? Bill. Good seeing you in person.
I want to push you a bit on Prop 12.
Yeah.
It actually might be a good thing, especially for Maryland farmers to be Pennsylvania farmers. Why should Maryland farmers have to adhere to more stringent standards in their nutrient management? Why are they a competitive advantage against Pennsylvania farmers who don't have strict Maryland legislatures? You know, we have to pay the cost of today. Our Maryland department are really contributing what they can. It should require Pennsylvania parcel.
I mean, there's,
Wrong with it.
I think the biggest part that could potentially be wrong with that is we don't then know where, if that product would even come into the state and where some of that product's even coming from to be able to meet that qualification to do that, because it would depend on how, we would probably have to implement more than just Pennsylvania in that and bring in a few other states. But yeah, you have a good point. We could use it in that way to where it limit some competitive disadvantages that we have in some areas. So yeah, I wasn't trying to be all gloom and doom on it, but yeah.
Issues with regard to that. But I think
Mhm.
things that are trying to protect. While others are. Have minimal requirements.
That's a good point.
Let's do questions on the mic so that the Zoom
Oh,
attendees
yeah.
can hear.
I keep forgetting we have people online.
Any other questions?
Uh-oh, Colby's got one. This really is Stump the Chump now.
So I wanted to get your thoughts on the PFAS discussion that's going on and the new emerging issues with the possibility of it being at the federal level, high levels of PFAS on properties becoming Superfund sites, and what would be the impact of a farm that uses, let's say, biomass from a wastewater treatment
Oh,
plant
God.
that has never been tested for PFAS and now has passively exposed a farm to PFAS.
So some of this I have to get back to you on because it's been a while since I actually looked at the Superfund law. So I have to remember how all the liabilities work out in the Superfund law, because that is not but there could be potential problems where then that farm is held on the hook for a long list of future claims within that. This is that was my initial caveat for me not remembering how the Superfund law works out off the top of my head. Yeah, no, I get that's a big worry, because if that does happen, that opens up a long line of liability potentially. No other questions? I bored y'all all to death. That's good. None online? I don't have my iPad in front of me this time. It was easier to monitor when I was moderating. I'm good. Oh God, Holly's got one.
So just, I wanted to clarify or something. So you're talking about the Coke settlement and
Mhm.
that growers were receiving claims. Is it only Coke growers or was it all? Because that wasn't clear to me.
It's
Is it
all growers. It's all growers that are growing for those companies, because we've seen
For any of the companies, even the
Purdue
ones
and-
who haven't settled yet?
Yeah, because they're all going to be lumped in the same settlement, and apparently right now Coke's going to pay for all of it. Because it's a class action and all the plaintiffs and defendants have been lumped together, so they're all
Even,
going to pay together.
even if the other
Yeah.
companies neither settle or go?
That's my understanding.
Well, I'm glad Coke's not
And-
in our area.
I know,
I didn't say that.
mainly Oklahoma and Arkansas. So I'm done.